Right. Good morning, everyone, and welcome to our annual employment law update. My name is Cece Mortar, and I'm the Director of Business Development and Programs here at the Chamber. Before we get started, just a few quick housekeeping notes. Please put your questions in the chat as you have them. There's three sections to this presentation, so we'll try to answer them within those three kind of sections. If you have an anonymous question, feel free to put it in the Q&A. You can do so anonymously. There's a little toggle box there. Make sure that your chat is set to everyone so that everyone can see your chat. And then before we get started too, I just want to give a quick thank you to our sponsors who make this series possible: Mountain Valley Bank, Northwest Data Services, UC Health, Colorado Housing and Finance Authority, and Routt County. Now I'm thrilled to introduce today's speaker, Tina Harkness. Welcome back. She is General Counsel at the Employers Council, and with over 20 years of experience in employment law and HR, Tina is a trusted advisor to employers across our region. She specializes in civil rights, workplace investigations, and compliance strategies, and is known for making these complex legal topics clear, practical, and actionable. So Tina, we're so glad to have you here with us today. I know you have a lot to talk about, so I'll let you take it away.
Thanks so much, and it's great to be back. We've got quite a bit to talk about this year. Cece and I were just saying there's a bunch. So we'll dive right in. I'm going to go ahead and share my screen, and just so you're aware, you will get a copy of the slides following the session. I always work up to the very end, checking things and making sure I haven't missed anything. I like to give it after rather than ahead of time for these legal updates. So, Cece, or the slides look okay to you?
They look great.
Okay. So just the stuff that I gotta say. Please don't take and use these slides anyplace else. Also, if you have specific legal questions, just know that the presentation can't advise you or your organization on those situations. But if you're a member of Employers Council, you can call in and get that individualized consultation. So this is just general. As for trends, I always try to see trend lines in what we're doing here. Certainly, and you guys see them too, and you probably know these very well, but we're certainly seeing increased uses of AI at work, and some of those efficiencies that can be gained, and then some of the cautions and some of the legal issues that can come with. And we'll talk about Colorado's AI law when we get to the Colorado update today. And we're certainly seeing in the last 12 months increases in in-person work requirements for employers that may have gone fully remote or hybrid in COVID. We're seeing some of those trends switch. Now, I think that's with mixed results from what I'm seeing, but that's happening. Also seeing a rise in disability accommodation requests, particularly in the area of mental health. Now that's been going on for some time, even pre-COVID, but only accelerated with some of the challenges that presented itself to individuals during COVID and after. Also a rise in religious accommodation requests. You might recall, or you might not, a couple of years ago, the Supreme Court changed the standard for religious accommodations from a de minimis standard to a higher standard, or raised the standard for what an employer must do for employers or for employees who need accommodations for their religion. So that has probably contributed to this uptick. And then, as has been the trend for many years, states are continuing to drive employment law change. We get very little legislation through our federal Congress these days pertaining to employment laws. So we do, and we will spend time talking about the change in approach, right, to the laws that exist in our federal update coming up next. But states are mainly where the employment law changes are happening. And Colorado is among more progressive in the nation in that front. So for our federal update, we're about at 120 days or so of the Trump administration. Some people are calling it Trump 2.0 and 1.0 for the first administration. Some things are the same as Trump 1.0 and Trump 2.0, and some things are different. So we certainly are seeing, and I know you're reading about the shrinking of the federal government, mass layoffs, particularly among some of the agencies that monitor employers. The National Labor Relations Board, the Office of Federal Contracts Compliance Programs, the Department of Labor, the EEOC have all been targets, have all had layoffs and significantly reduced in size. Along with that is the shifting of enforcement priorities for those federal agencies, mainly through executive orders. There's a bunch of them discussed in the presentation today. We also have a freeze placed on new regulations. So regulations are interpretations of the law that, if they go through the full Administrative Procedures Act process, have the force and effect of law as well. So the president has definitely signaled that we don't want more regulations, we want fewer, and has even gone so far as to say that he wants to see a 10-to-1 deregulation. So eliminate 10 regulations for each new one that gets put in place as a goal. We're also seeing the rollback, and we'll discuss further, of federal government DEI programs and extending to enforcement into the public and private sector for organizations and businesses, and major changes to the federal contractor affirmative action rules. Definitely seeing an increased focus in workplace immigration enforcement, and again on that religious accommodation front, and many, many executive orders. And that's not just true of Trump. President Obama, President Biden, the first Trump administration, I think it might even go back a little further than that, where the presidents have used the executive orders to facilitate some of the changes that they want to make that maybe Congress was not as receptive to. So let's talk about what an executive order does. So we have co-equal branches, you know, from your civics class, of the federal government, Congress, the courts, and the executive branch, which is of course headed up by the president and made up of the federal agencies. So the president can issue executive orders to direct what federal agencies do and how they operate. And it definitely impacts, as we've seen, funding, staffing, and it will impact the operations of organizations that get federal funding, as we're seeing this year. But executive orders don't create new laws, and they don't override existing ones. So we'll talk about some tension between some of the executive orders we've seen this year and current law. But it certainly influences, through those federal agencies, how laws are implemented and enforced. Also, executive orders cannot overrule case precedent. So that's previous court decisions. So in the United States, we follow a concept of stare decisis, which is, you know, let the decision stand. So we follow the higher courts in our different hierarchies at the state and federal level, all the way up to the US Supreme Court. We're following decisions that came before on those same topics, unless there's a change or a reason to distinguish that decision from the next. And you know, from reading court decisions and hearing about court decisions, that courts do find lots of reasons to depart from past decisions, but we'll also highlight some areas of conflict between executive orders and some case law that is on the books in the United States. Starting with DEI changes, these two executive orders came out, I think the first or second day of the new Trump administration. And the first one really probably doesn't impact most people on this call, but it ends DEI programs within the federal government. So some of those layoffs right away were different DEI positions within our federal government agencies. But then the next order really did have an impact on many businesses, including Employers Council. So it revoked executive orders requiring affirmative action based on race, color, sex, sexual orientation, religion, and national origin. So that, if you are familiar with the numbers, was Executive Order 11246 that was signed by President Johnson in 1965. So that has been in place, and affirmative action has been required for federal contractors and subcontractors since then. But because it was an executive order that created those affirmative action requirements, it could be repealed, and was repealed by Trump's Executive Order 14173. So those of you who are affirmative action employers, so that's again, federal contractors and subcontractors with at least 50 employees and 50,000 or more in federal government contracts per year, your annual affirmative action effort changed a lot. Because you no longer have to have an affirmative action plan for these protected statuses. Now, I do want to make sure that you're aware that the Rehabilitation Act is a separate law, and that is what requires affirmative action for disabled individuals. And VIVRA, which I can never remember what that stands for. If somebody can, you get a 10,000 points this morning. So VIVRA is the Vietnam era Veterans Employment and Reemployment Rights Act. I didn't get that right, but that's close enough. And that is still in effect as well. Now, that VIVRA was specifically enforced by the Office of Federal Contracts Compliance Programs, which is one of the agencies that has had a 90% layoff. So I don't expect a whole lot of activity, but there is by the agency, but there is an avenue to there's just still that avenue, and you do still want to have your veterans plan in place. So in light of these orders, to the extent that you have DEI policies, programs, practices, training, you're going to want to take a look and maybe consult with your counsel on are there any riskier or potentially problematic areas. And if you're covered by affirmative action requirements, continue those for veterans and disabled. I don't believe in Colorado as much, but in other states, there may be state or local affirmative action requirements. If you're operating and having those state or local government contracts, you want to, of course, continue any of those requirements for your contracts. Really what we're seeing is we want to focus on inclusivity, that the words that have been more politically charged are the equity piece and the diversity piece. But we know that DEI goes beyond that to creating a sense of belonging in our cultures and a sense of inclusivity in what we're doing as an organization, as a business. So those things are where I would place your focus these days. And of course, continue to investigate all complaints. Title VII, which is our Civil Rights Act in the United States that applies to public and private employers, has not changed. Quotas and preferences based on protected statuses have always been unlawful. So just make sure your programs are geared towards including, not excluding, and open to all employees rather than highlighting or singling out different groups for different experiences. We did get some guidance on what is illegal DEI from the Department of Justice and the EEOC. And Department of Justice enforces this in public accommodations. The EEOC enforces the employment aspect. So that's why it's joint from the two of them. And they really kind of took aim at, again, the preference kinds of programs that, again, not many businesses ever had in place. And again, were potentially always problematic. And they also went after limited membership employee groups that some businesses had, where they had the different protected groups meeting and supporting each other in their workplaces. They went after that. They want those groups to be open again to all employees. And they highlighted DEI training in a few places. What surprised me is they talked about DEI training might give rise to a hostile work environment claim, or opposing that training could be considered protected activity and form the basis of a retaliation claim. So DEI training was definitely focused on. So if you're doing that training, again, speak to your counsel about how best to conduct that training in this current climate and going forward. Other changes in the equal opportunity space, we have Executive Order 14168 that directs federal agencies to recognize two sexes, male and female. So the non-binary options that have been in place on some forms and in some processes will go away. The EEOC is also shifting away from pursuing sexual orientation and gender identity claims, and has retracted portions of its guidance on workplace harassment about protections for sexual orientation and gender identity. Now, that arguably is in conflict with the Supreme Court decision in Bostock versus Clayton County, Georgia from 2020, which held that Title VII's prohibition against sexual discrimination includes discrimination based on gender identity and sexual orientation. So again, the executive order doesn't change that case precedent. Congress could enact a law that changes things, or the Supreme Court could overrule itself, as it has in some cases. But for now, you certainly should be continuing to follow Bostock, because you can still be subject to court claims under the federal law, which is Title VII. And in Colorado, we have both state and local prohibitions against gender identity and sexual orientation discrimination. So continue to follow those. Other EEO changes, excuse my creature here, I apologize. EEOC is expected to rescind its final rule on Pregnancy Workers Fairness Act. So the act itself will remain in place, but some of the rules requirements, particularly the requirement of accommodations for abortion and abortion-related services, is probably going to cause this rule to be changed going forward. And we have more recently an executive order to end enforcement by federal agencies of disparate impact discrimination claims. So under civil rights, there are two basic types of discrimination. One is disparate treatment. So that's intentionally signaling out a person or a group for different treatment, better or worse, from others based on a protected status. So that's the intentional kind of discrimination. But then we've also had, since a Supreme Court decision in the 60s, Griggs versus Duke Power, we've also had the unintentional type of discrimination, where employer has a neutral policy or practice that in its application discriminates based on protected status. So that's usually shown by statistical evidence, and that has been actionable again for some time. So even though the federal agencies are shifting away from enforcing disparate impact discrimination claims, we have Title VII and state and local laws that allow disparate impact claims. So we still should be looking at our policies and practices. Maybe it's hiring, maybe it's reductions in force, which some of us are having to do these days. We should still be reviewing those for the potential of adverse impact on protected groups. And of course, Colorado has its own Pregnant Workers Fairness Act. We had this before the federal act passed, and that still does require pregnancy accommodation under the Colorado Act's terms. So you would want to make sure you're following that. All righty. I wanted to let you guys know, those of you who are covered, private employers with over 100 employees, or again, federal contractors with 50 or more employees and 50,000 or more in federal contracts, are subject to the EEO-1 filing each year. That's still in place. The executive order rescinding affirmative action and changing other things did not change this. There's also an EEO-4 that state and local governments with 100 or more employees need to fill out. And the reporting period just opened a couple days ago for this. It's shorter this year. It's only 5 weeks. So if you are used to a longer reporting period, just prepare and get that going because you only have until June 24th to put that in place. And in consideration of the executive order, recognizing two sexes, the non-binary reporting option that used to be present in these forms is being removed. Immigration changes. There's a lot of executive orders here, and one of them mandates prosecution of illegal immigration to the fullest extent of the law. So that is a change. We're very much out of a compliance approach and in an enforcement approach to immigration. And it's not just with individuals as we're seeing, but also with businesses. The U.S. Citizen and Immigration Service is looking at employers who are sponsoring foreign nationals and those that are using H-1B, H-2B visa programs and that PERM labor certification process for getting green cards, even though they haven't been green for years. They're looking closer at those organizations. And we've certainly seen a recent surge in I-9 audits. I attended our I-9 and immigration enforcement webinar that we held yesterday with an immigration firm. And what she said is that we're going to be at the highest level of I-9 audits and ICE raids. You know, we're on target to be at that highest level. That the highest year in recent memory is 2023, and there were 600 or so of those. And we're on target just in the first few months of the year to have more than 1,000 of those I-9 audits and ICE raids. Now we are seeing reductions in those agencies as well. So, and layoffs. So those staff and those smaller budgets can cause delays in visa processing. They will, they already are causing delays. So it's taking longer if you do use those processes. And although we didn't get one immediately this time, in Trump 1.0, there was a travel ban issued, I think the first or second day of his presidency. We're at 120 some days. We don't have one yet, but it is expected. And then there will be limits on employment authorizations to go with that as well. So think about your workforce planning. If you are using, you know, a lot of these visa workers, expect those delays and think about if you need to pivot in different places. Definitely conduct a I-9 audit, either engage a third party or do it yourself to make sure you're in good shape if you do have ICE coming to look at those. And then certain industries, I would, you know, if you don't already, think about what your response plan would be if you were subject to an ICE raid. So for your internal audit, you have to have an I-9 for any employee hired after November 6th, 1986. Now, if you still have somebody working for you, please tell them to retire. But if you do have somebody working for you before that time, they will not have an I-9 form if they've worked continuously for your organization, but that's a really long time. All right. Certainly review your I-9s for any missing information, any errors, any discrepancies. It's definitely important to follow the rules for how you make corrections to I-9 forms. It's very rarely the answer that you do a new form, although sometimes that is the answer. Most of the time you are making corrections, but no whiteout on these forms, that they've got to see what it said before and see what your corrections are. So you don't want to, you want to do that correctly. So make sure you're consulting. I've given you several resources. The first one is our white paper on auditing your I-9 forms. I-9 Central is a government repository of information, and that handbook for employers, many of you are familiar with, that's been around for years to help employers with the I-9 process. We've always said, get rid of the I-9s, you don't have to keep anymore. So your retention period for former employee I-9s, just for former. I had one member who thought they could throw them away for current. No. For former employee I-9s is you have to keep it the longer of 1 year from termination or 3 years from hire. So it is a balance. So make sure you're ticklering those of your former employee I-9s for when you can purge those. So if you're going to be audited, you're going to get sent first a notice of inspection letter. And they are so far mainly targeting border states and what they call the charm industries. So construction, hospitality, agriculture, retail, and manufacturing. And they also are really looking at repeat offenders. So if you have been audited before, that ratchets up your chances of being audited again. It also increases your potential for fines, because first offenses are fined at a lower level than second or subsequent offenses. The fines for violations on the I-9 form and technical errors are, of course, lower than the fines for employing unauthorized workers. And as I said earlier, the executive orders are instructing the agencies to pursue the maximum penalties available under the law. So I think we can expect that where there are penalty ranges, that those agencies will be pursuing the higher end of those ranges, and where there are criminal violations available or found, excuse me, that they could pursue not only those fines, but also prison time. So we've seen 2 employers that have been criminally charged for harboring. So that is kind of a practice of shielding unauthorized workers with knowledge that they're unauthorized. You might have seen the Abby's Bakery and Dulcie's Cafe in Los Fresnos, Texas. I'm sorry if I'm pronouncing that incorrectly. So we are seeing that. Also at stake is debarment from federal government contracts and potential back pay if you're found to have discriminated in your I-9 process or in your immigration processes based on national origin. So you've refused to hire when there wasn't a reason not, or on that basis. For an ICE raid response plan, I'm not an immigration attorney. I have been attending a bunch of different sessions on this at the first part of this year. So these are just a few things, particularly if you're in those charm industries, that you might want to take a look at. One thing that was highlighted in the last webinar I attended was to mark what portions of your workplace are public and private. Because depending on the type of warrant ICE has when they come, whether they have a administrative warrant that they issue themselves or a judicial warrant, that may get them into certain places of your workplace. the warrant should issue, again, the description of the premises to be searched, a list of items or people that are being searched for. And again, they should have, if they're a judicial warrant, the judge's signature and date. If they're an ICE administrative warrant, it's going to be signed by an ICE representative. So look for those kinds of things and figure out, your channels of communication and who's going to be interacting with ICE for your company, and keep those detailed records. We do have a new I-9 form. They changed, they had a couple of minor changes, as you'll see, a lot of it in response to the executive orders, changes in terminology, really. The new form is dated 1/20/25 and expires May 31st, 27. Although that new form is available, the two previous editions of the form, which are noted here, also remain valid and have the same, well, one of them has the same expiration date. The other one has a little earlier expiration date. So you can use those as well. So you got 3 options for I-9 form right now. Wage and hour, we're likely to see the Trump administration stop its fight to raise the minimum salary level for exempt employees. You might remember the Biden administration attempted to do that in 2 phases. The second phase was enjoined, and then the whole rule was wiped out. That the Biden administration was appealing those decisions to wipe out those changes, and the Trump administration may do what it did in Trump 1.0 and stop that fight and then go back to the drawing board to decide if they want to issue their own rule on what the federal minimum salary level should be. The Department of Labor has retracted the Biden era more restrictive independent contractor test. They've gone back to the economic realities test, which is a little looser, meaning more workers can be considered independent contractors. And then we've had some action on, we've had for years a sub-minimum wage for workers with disabilities. Very few employers use it, but there were plans to get rid of that, and those are on hold with everything else. So we have in Colorado our own, for private employers, minimum salary level for exempt employees. So if you're a private employer, you're already paying a heck of a lot more than the federal standard. For our public sector employers, our governments and special districts and entities funded by public monies, you are still subject to the former rule of $684 a week or $35,568 a year until the court case or the Trump new rule comes out. Colorado has steeper, more comprehensive independent contractor tests than the economic realities test. So for you folks here, make sure you're paying attention to that. And Colorado is phased out. It's sub-minimum wage, is in the process of doing that. Actually, they did it ahead of schedule, so you should not be paying a sub-minimum wage. AI changes. So Trump has issued his own orders to remove barriers to AI innovation, and the EEOC has removed the technical assistance documents it had on its website that were to tell employers what you need to check if you're using AI to prevent adverse impact discrimination or disparate impact discrimination. So I realized I used disparate on one slide and adverse. That's the same thing. So although, again, those changes have been made by executive order and to the enforcement positions, if you're using AI for employment decision-making, do make sure that you fully understand and document and that you're able to explain how it works and what it does. Because employers are getting sued under Title VII because disparate impact is still actionable under Title VII for their AI processes. You might have heard of the AI that was used to review resumes, and it was screening out female applicants at a particular age and male applicants at another age. And the employer, argument was they didn't know it was doing it. They didn't instruct it to do that, but they still were using something that was doing that. So be careful, make sure that AI is not adversely impacting protected groups. And we have, and we'll see, it's not yet implemented in Colorado, the broadest AI law in the nation, which we'll talk about soon. OSHA, they've been cut. They aren't likely to be issuing any new standards. That heat illness standard is unlikely to be finalized for those of you affected, but it's still a national emphasis program. OSHA is still going to respond to complaints. They're going to issue citations, but likely on a reduced scale. And they're going to be more involved in compliance programs, consultation, training, and education. That's just typical of how OSHA operates under Republican administrations in the past. There are some states that have state OSHA requirements. Colorado is not among them, but if you operate in New Mexico, Arizona, Utah, Wyoming, they have their own programs. So make sure you're following those. Labor relations wise, it's taking a while for the board to reach quorum and to get members, new members onto the board. Right now, there's only 2 members, and Trump fired the general counsel and the deputy general counsel early on, and 1 Democratic board member. So the NLRB has not been able to operate so far, but once there are new board members appointed, they're going to reverse the current positions on these items. And the new acting general counsel has already rescinded over 30 guidance memos that came from the previous general counsel, Jennifer Abruzzo. So if you have unions, if you're in union negotiations, if you're dealing with an election campaign, likely the playing field has changed. Non-compete agreements, Trump administration likely to stop its fight to enforce what the Federal Trade Commission was trying to put in place, which was pretty much a ban on all non-compete agreements. But we know Colorado has its own rules on that. All right, Cece, I didn't see anything pop up. How are we doing on questions?
There are a couple in the chat. So the first one is the audit in person. How much time do you have to complete the audit or otherwise prepare?
For the I-9 audit, does that sound?
Mhm.
Yeah, I think that they're giving you, they used to give 3 days. I haven't seen the newest, but yeah, it's usually a few days. So that's kind of your time, if you haven't remediated your I-9 forms, to take a look at that and see if you can make some fixes in advance.
Okay. And then the second question, tax on tips, when will that go into effect?
So tax on tips, or you mean the attempt to take that out of being taxed? Is that what we're talking about?
I think so. Joey, can you confirm that that's what you were looking for?
So Trump spoke in his campaign about wanting to remove taxes from tips and overtime. And there has been some movement in the federal Congress, but it's not in place yet. Now, I do have a bill for Colorado that is going to allow those areas with local minimum wages to take a tip credit, but the federal piece has not happened yet.
Okay, thank you, Tina. That's all for now.
All right. So case law, last term, the Supreme Court's term runs October to the following June. So in the 2023-2024 term, we got this decision that overturned a case called Chevron, which was a previous Supreme Court decision, which said that when federal agencies issue guidance on interpretations of the laws that they enforce, the court should give that guidance from the federal agencies some deference in making their decisions that are applying that guidance. And the Loper Bright Enterprises case wiped out that Chevron deference. So courts have to use their own independent judgment to give the statutes their best meaning. So the quotes are intentional because that's what we're going to be figuring out, or that's what we're starting to figure out since this decision. So this basically made challenging agency rules and guidances a whole lot easier. And that's what we're seeing, just what we have discussed at a federal update. There are several guidance, the Pregnant Workers Fairness Act, the sexual harassment guidance that the EEOC issued, and the overtime rules. All of those are being challenged, and this just gives more fuel to that fire. And it's also going to lend a little more uncertainty because the judges, there are more judges than there are federal agencies. And if you don't have to defer to the federal agencies' guidance, then you could have judges making all sorts of different decisions to try to give the statute, in their opinion, its best meaning. So we'll see what that goes. But this is weakening the authority of federal agencies. We also saw in this session already a decision that is good for employers, yay, that held that the burden of proof for showing that a worker is exempt should remain the same as it has, which is a preponderance of the evidence. We had one court depart from that standard. I think it was the Fourth Circuit that said that employer has to show it by clear and convincing evidence, which is a higher standard. So preponderance might be here, clear and convincing's up higher than that, somewhere floating in space. And so it's already tough enough when it's our burden to show that an employee is exempt from the overtime and minimum wage requirements under federal and state law. So this would have made it tougher. And we're sticking to the standard that we have had in this circuit all along, and that is the law of the land. We also had a case that wasn't an employment case this term, but it was around the issue of attorney's fees. And, when people go to court, they can get different remedies. A lot of times they get money, but sometimes they get what are called equitable remedies, and injunctions are among equitable remedies. So injunctions are to stop something from happening or start something from happening. So in this case, the plaintiffs were Virginia drivers whose licenses were suspended for failing to pay court costs or fines. So they sued under a section of civil rights laws applying to public entities called Section 1983, and they got a preliminary injunction, and then they sued for their attorney's fees. And in the United States, we have two options for attorney's fees pertaining to attorney's fees. The American rule is the baseline. So, and that is each party pays their own attorneys. But we also have many statutes that change that American rule and say, instead, if you prevail in a lawsuit, if you're the prevailing party, then you can get the other side to pay your fees. And civil rights has been one of those areas where the statutes have had this prevailing party standard. And in this case, this is clarifying when you win. So a preliminary injunction isn't enough to win and get your attorney's fees. So that's going to go outside of this Virginia driver's license case. That's going to apply in many situations, including employment cases. And it's really because no decision is being made on the merits of the case when a court issues a preliminary injunction. This term yet to be decided is the Ames versus Iowa Department of Youth Services case. So we're going to watch for this one. We'll report on it when it comes out, again, by June. So it should be soon. So this is on reverse discrimination and what should the standard be for proving reverse discrimination. And in a discrimination case, most of the time you're following what's called a prima facie case. So I'm in a protected class, I was treated differently, despite my good performance or despite others behaving worse than me, and there's no good business justification for it. So that's the prima facie case. Then the employer gets to show that they have a legitimate business reason for doing what they did that isn't an illegal one. And then the plaintiff gets another shot at the employer to say that's fishy, that there isn't support. That's a pretext for discrimination. It's not the real reason I was let go, or I was not promoted, or I didn't get my pay increase, or whatever else. So majority group defendants have in certain circuits, including our 10th Circuit. So 5 of the 13 circuit courts across the United States have held that if you're in a majority group, a historically favored group, that you got to make more of a showing than just the regular prima facie case. So you have to have some background circumstances, some additional information that shows that this is an employer who discriminates against a majority group, a historically favored group. And the Supreme Court took oral argument on this on the end of April. And the commentary and the questions seem to indicate that the Supreme Court is going to rule for Ames and say that it's the same test. It doesn't matter if you're a majority group or a minority group plaintiff, it's going to be the same test. So that will change the standard in our area for reverse discrimination claims. Also wanted to point out the Double Eagle case. This is 10th Circuit, so this is over Colorado and many of the surrounding states. It's a trade secret case, and this case, look at this. Employee left the employer for a competitor, taking their notes and 2,600 digital files containing their former employer's financial, technical, and business information. So doesn't that like let ice flow through your veins for just 1 second? The employer's case was dismissed for 2 reasons. So I don't want any of you in this position. One, the employer couldn't show that it was protecting the information that this employee took. So you have valuable information for your business that you don't want your employees to take to a competitor or your competitors to have. So protect it. Make sure it's behind a firewall. Make sure it's marked confidential. Make sure it's not allowed to leave your premises or leave your communication systems. Put some training in place so employees know you don't leave this stuff open on your computer when you walk away from your desk. You don't leave this stuff out on your desk if it's in paper form. Do those things for your proprietary information. The other reason they lost is they could not identify that what the trade secret information was separate from general knowledge in the trade. So general know-how is not a trade secret. It's just not. But the formula for Coke, right, and the Colonel's secret recipe are, so those are things that that are going to be different from just how do you fry chicken and how do you make soda kind of information. So you cannot prohibit people from using their general know-how from working in the industry when they leave you, but you can tell them you can't take our specific ways of doing things with you when you go. We did have a Colorado Supreme Court decision on overtime under the Colorado Wage Act. So private employers, public sector, you can tune me out for a couple seconds. But private employers are subject to the Colorado Wage Act. And if you pay holiday incentive pay, so this is extra pay you pay employees for working on a holiday. So this is non-exempt employees, right, who are entitled to overtime. If you pay them extra pay, like we're going to pay you your regular pay plus X for every hour you work on a holiday, that holiday incentive pay does need to be included in the overtime calculation for that pay period for that non-exempt employee. So just make sure you're doing that because Amazon was not doing that and they got into some trouble and owed some back pay. Now, holiday pay is distinguished from holiday incentive pay. Holiday pay is pay you pay a non-exempt employee for not working on a holiday, so that they, because you're closed and you want to support them in spending time with their families and friends and celebrating that holiday. That holiday pay does not have to be included in the calculation of overtime. But if you give them a bump for working on the holiday, that does. All right. Any questions, Cece, on that section?
No questions yet.
Okay. Let's get into Colorado. This session, I wrote the blurb and sent it to Cece, and then Governor Polis vetoed a couple of the bills that I was going to talk about. So we'll talk about them in the end because they didn't happen. But the session was from January 8th to May 7th of this year. So the bills that passed both houses of our legislature are now in a process where the governor can sign them, and he needs to sign them within 30 days at the end of the session, which is by June 6th. He could veto them, and we have had some vetoes, although that's unusual for Governor Polis because he works very closely with the legislature every year on what he wants to see them do. So he doesn't veto bills often, but he did this year. And then the other option he has is he can just allow the bill to become law by without his signature. So he does that sometimes too. He's got a little time to sign some of these, and I've noted if they've been signed and if they have not been signed. So before we get into this session, I just wanted to have a reminder from the last session. For those of you who do collect biometric data from your employees, so fingerprints, retinal scans, handprints, different things and photographs that are used for identification purposes, then you do need to prepare yourself by July 1 for the law that passed last session. Um, so this means making sure that you've got a biometric policy, that you've got consent from your employees and prospective employees to gather and retain that information. You've got a retention schedule laid out. You've got breach protocols in place so that that information doesn't get accessed improperly, and destruction guidelines. So take a look at what biometric data you gather and get ready for that. I mentioned AI and different state laws, including Colorado's law, which passed last session as well. But it sort of passed and was signed by Governor Polis with the understanding that the legislature would come back this session and soften it. So Colorado's law is considered the broadest state AI regulation in the nation. It is not in effect yet. It is going into effect February 1st of 2026. So again, Governor Polis signed the bill asking for revisions. And there was a bill to try to revise it, but they could not reach consensus on it. And they ended the session without making any changes. So they won't have much time next session, which begins January 14th of 2026, to do anything with this. So we will see what happens. The other thing that's happening politically on this is that the Republican members of the House Energy Commerce Committee and the federal Congress want to put a 10-year moratorium on state laws regulating AI. So this would be in line with the executive order removing barriers, right, from AI innovation that we talked about earlier. Now, Governor Polis has said he would support a moratorium because he does think there should be a federal solution to AI rather than a patchwork of state regulation on this. But he doesn't want it to be for 10 years because the horse will be well out of the barn and all the way across the state by then. So we'll see what happens with that. The tech industry has encouraged Polis to bring the legislatures back to a special session. The Constitution in Colorado gives him the right to do that at any time. I haven't seen, and I did some searching this morning, I haven't seen any indication of that so far, but we'll see. We did have a law passed that would restrict employment agreements, non-competes, basically for physicians, physician's assistants, dentists, and registered nurses. So we've had limits on non-competes for years, and we had some major ratcheting down of non-competes a few years ago. So not many businesses use them. And it's been improper to have non-competes that prohibit physicians from practicing medicine for some time. But it did allow recovery for damages if the physician left and opened a competing practice and the practice that they were formerly with was harmed by that. So the new law is going to remove that ability to recover damages. It's mainly in that medical industry where you might be affected if you're using non-competes. So this is another change to the Colorado Wage Act. And I got to tell you that for private employers in Colorado, it's getting harder and harder to defend yourself from wage claims. So they're broadening with this bill the definition of employer to include 25% owners. So that's another potential plaintiff. They are making it harder for courts to award attorney's fees to employers. The same standard, there's a different standard for employees. An employer will have to be able to show a higher burden to get their fees paid if they win a wage claim. Right now, the limit for when a private employee can go to the state for a wage claim is $7,500. That will go up to $13,000 for claims after July 1 of 2026. And then it'll be adjusted up for inflation after January 1, 2028. So there's going to be more of those wage claims because of the amount increasing. The CDLE, Colorado Department of Labor and Employment, is going to publish a naughty list on its website of employers found to have violated the Wage Act. And if that violation is not remedied within 60 days, they are going to be obligated to notify government agencies that give you your license, your permits, your registrations, your credentials to start processes to take those things away. So again, getting harder and harder and more punitive on employers all the time. Also, the division is giving themselves more time to decide wage claims because they're going to get more of them and they have a lot of them already. And this is concerning that if an employer takes adverse action against an employee within 90 days of that employee filing a wage claim, it's going to be presumed that that is a retaliatory employment action. And of course, there are consequences for retaliating for people coming forward with wage claims and fines and penalties for that. So that's going to be presumed, and the employer is going to have to overcome that presumption with evidence that it was not retaliatory. So it's going to put more pressure on those near-term employment decisions you might make about an employee who's made a wage claim. There's some immigration pieces to this too. We saw a lot of that in this session, not just employment pieces. And the CDLE being allowed to award reasonable attorney's fees based on their investigations. Reasonable being the operative word there. Sometimes attorney's fees don't feel reasonable, but we'll see what the CDLE thinks they are. Couple changes to the Colorado Anti-Discrimination Act. So this is public and private, so publics, you can come back and pay attention now. The remedy provisions are going to change. They're going to go up. They never really go down in these claims. And that's going to be effective in August. They're fixing a problem where a defendant could show a good faith effort to correct a violation of the Colorado Anti-Discrimination Act and be entitled, this is the one good part for employers, so I want to talk about it, and be entitled to a 50% reduction on a non-economic loss or injury award. Again, so if you're found to be in violation, if you correct it, make a good faith effort to correct within 30 days, or you're able to correct it entirely in that time, then your damages, your non-economic damages could be reduced by 50%. So that's a big deal. And we also had the addition of dead naming, which is calling a transgender person by an incorrect name. For example, the name that they might have been given at birth that they do not use anymore, or misgendering. So not using the gender that they identify with, the pronouns perhaps that they identify with, that they've informed you are their pronouns. They've made that to be separate discriminatory acts under our Colorado Anti-Discrimination Act. Some other bills. So workers' comp always gets changes every session, but for many years, employers in Colorado have had to designate physicians, right? You've got 4 physicians you got to designate, or if you're in a rural area, at least 2 at 2 different locations, right? And you communicate that and send out that notice. That is going to change in 2026, where a worker will be allowed to choose their primary treating physician. If the worker doesn't choose someone, which would be rare, I would imagine, then the employer or the insurer can do that. But we're going to have to give employees who are injured on a work-related injury a notice of their right to choose a provider within 7 calendar days of that injury. So again, this isn't going to affect right away, but that will be changing our processes for work injuries and who the employee can go to in next year. All right. And we had a bill passed that also changes our family program, adding an additional 12 weeks on top of the current 12 weeks of family for a parent of a child receiving care in a neonatal intensive care unit. And that'll be again for claims after January 1, 2026. So you could have somebody out for longer under family than what is currently available. And then it's going to program or allow for the incremental increases to the premium rates. So those are going up. An employer and the employee's contribution for most employers. Employers with 10 and fewer employees, it's just the employee's contribution. And then for you public sector folks that have opted out, you have no contribution. There's a bill creating a civil cause of action for peace officer with whistleblowers. So if they're reporting what they think is some malfeasance or problems in police department or the sheriff's department, then they'll have some protections and a specific claim that they can make. And it will not be subject to governmental immunities. So employers, public sector employers get a fair amount of protection from the Governmental Immunities Act. This is specifically not something that you could use the Governmental Immunity Act as a defense for. We have another bill that allows for project labor agreements on public projects. And this is that tip offset that I mentioned for places with local minimum wages in Colorado, which I think is just Denver, Boulder County, Edgewater. Forgive me if I've forgotten one there. And then the vetoes. So we had 2 vetoes this session. They were both in the blurb, so I apologize if you came to hear all about those bills. First one would have extended deadlines for public entities responding to Colorado Open Records Act requests in certain situations. So they would have still had to respond to requests from the media in a fairly short amount of time. But if that wasn't a media inquiry, they would have given more time to the public entities to respond to those requests. Means they can be very burdensome for public entities to process those. Sometimes there's a lot of them. So that poll is vetoed. Also, the one that got the most press this session, which was to change the Colorado Labor Peace Act, which comes into play with unionized environments. Once an employer has a union in Colorado, Colorado requires a second election under its state law for a union to put in place what's called a union security clause, which means that everybody who's hired by that employer has to pay dues to the union. So all workers are forced to pay fees. They can't be free riders and get the benefits of the union's negotiation with the employer, whether they're members of the union or not. So Polis was pretty clear that he wasn't going to sign a bill that business and the unions didn't agree on. Well, surprise, they didn't agree on it. Now, this went down to the last day of the session, and the legislature voted it through. They passed it through the House and the Senate, and they sent it to the governor. And he vetoed it. So that is not in place. But that got the most press this session. I thought I was going to be talking about something different. But that's what I have. How are we doing, Cece? I think we have 7 minutes, right, for questions?
We have 7 minutes, and there's a couple in there. So as we go through these, for everyone else on the call, put in your questions. The first one is, does AI law apply to AI recording of minutes, taking of staff meetings and trainings?
So it could. So that I know that's a terrible answer. So I apologize. But the AI bill that was passed and signed last year is written very broadly. And that's really why the governor said you need to trim this. It applies not just in employment contexts, but in several other contexts as well. So we're using a lot of those AI note takers these days in meetings. I see them all the time flashing at the top of the screen. So I want to say likely not, because the intention again is to regulate so people know when it's being used, so people can opt out of potential use, so people can find out what's been retained or recorded about them in the different processes. So that's where I say maybe the note takers will come up. Now, again, it's not effective until February 1st of next year. And we hopefully will see some trimming down of that legislation, either in a special session, in a federal moratorium on state AI laws, or in the beginning of the Colorado legislative session. There's going to be a lot of pressure on the legislatures to take care of that and make it make sense, so that all the entities that are impacted can understand it and comply.
Thank you. What advice do you have for employers that are paying employees contract wage and issuing 1099 NECs when it should be a W-2?
Okay, so that you're going to talk offline about. So that's something to call your counsel about. If you're a member, to call employers counsel to look at your particular situations. Generally, again, if somebody's misclassified as an independent contractor who should be an employee, there are consequences to that, both under our federal laws, particularly taxes, tax implications there, and potentially wage and hour implications there if that person should be a non-exempt employee. And then in Colorado, we have our own state laws that set their own penalties for employers that misclassify workers. And those penalties under that bill that we showed earlier for private employers, again, in Colorado, are going to go up in the not too distant future. So you do want to look closely at those relationships and feel that you are in a strong position. In Colorado, you should have an independent contractor agreement with a contractor, because what that does under Colorado's law is it, instead of the presumption that we start with that all workers are employees, that flips that presumption if we've got an independent contractor agreement to starting at the place that this is a contractor, and the Department of Labor or the contractor having to provide evidence that it doesn't. And we've got that multi-factor test, which we know one factor is no more important than the other. That's that teeter-totter. So we don't want it like right in the middle. We kind of like it teetering towards contractor status as much as we can. So that's what I would say generally.
Okay. Thank you, Tina. Last chance for questions. Since there was a lot of information in this, Tina, what are the, if take away 3 to 5 things that they should go back to their offices and do in the next week? What would you say?
Well, I did put some to-dos. I know there were a lot of them. I think if you have a DEI program, I would look hard at that and make sure you're feeling comfortable. If you're in one of those charm industries, I would be prepared for an I-9 audit and potentially a raid. I certainly hope that's not the case, but we have had that in the high country in Colorado in the past. And we do have all those industries present in Colorado. So that's a bigger one. I would say the Colorado statutory changes are pretty specific. So if you are in those, if you are affected by those, make sure you're implementing those changes. But those would be my top 3 right now.
Thank you, Tina. And thank you everyone for joining. If you guys have questions that come up later, please feel free to email me and I can help facilitate getting those answered. I know this is a lot and it's heavy. So I want to thank you all again for being here, Tina, for the valuable information. And before we wrap up, I just want to let you guys know about our next free business education series session. It's on Thursday, May 29th, and it's an AI training for small business. I'll include those registration details in the follow-up email with Tina's slides and the recording, so you'll have access to her links and her to-dos. Have a wonderful Memorial Day weekend, everyone, and thank you again. We look forward to seeing you soon. Bye, guys.
Thanks. Bye, everybody.